And in virtual land?
Virtual land.
Okay, everybody? Okay. Okay, well, thank you for having me. And I'm going to address the challenge that we face, Jean and I, taking some of these issues into a court process. What we face is a swirling platform of competing narratives. And the court process is a search for the ephemeral truth. And we're trying to cut through a lot of smoke and mirrors coming from a misled or corrupted voice of the children involved and a strident voice of those putting forward false allegations. And in a forum that sometimes almost seems designed to get it wrong. So what the point I'm going to try and leave you with is that there are very robust legal remedies. Dealing with false allegations is well known, and the legal remedies for them, there's a deep body of jurisprudence that you can call on. But to get there, you need to analyze and present forensically. You have to think through and present the facts of the case and link it to the available law in a way that enables someone, a judge who wasn't there at the time, to get it right. And until you sit on the bench and have to deal with this, or you see the struggles that child protection workers and therapists and assessors and parental coordinators have in dealing with the competing narratives, only then can you understand the effort and the structured thinking in a forensic sort of way that you need to do if your goal is for everybody to get it right. If your goal is for people to get it wrong, it's surprisingly easy. So with that in mind, we will this works. Yeah. Okay. So the number one challenge, of course, is the voice of the child. If you start from the premise that children always tell the truth and that both parents are biased and lying, so let's just go with the voice of the child, you're going to get it wrong every time. The children are caught in the middle. They're triangulated. They may be living at the moment primarily or entirely with one parent, or one parent may be parenting using a passive aggressive sort of approach, or a child may seek to be pleasing a parent who they feel is vulnerable. They need to protect them. So there's sort of a role reversal or enmeshment dynamic going on. The voice of the child in these situations is extremely unreliable. And there's two aspects, as we'll see that later. There's both credibility. Is the child trying to achieve an effect? I want to live with dad, so I'll say everything possible to get what I want. But there's also reliability, and those are two different concepts. People can experience events two different ways. People can experience events where one person didn't really intend that their actions or statements be experienced the way they were experienced. So you can come out of this with two people not having experienced the interaction the same way. So, and apologies for some of the font problems. This was stitched together from different presentations, and sometimes PowerPoint doesn't like that. So we have different players. The different players in interpreting the voice of the child bring different standards and different rules and different perspectives, and the amount of time that they have to devote to a particular incident varies as well. Just because the police have recorded something at an interaction doesn't mean that's what happened or that's what was literally said. You won't know from their record what they didn't capture. Yes, they still use those little flip daybook things and eventually transfer that into a more formal report. Children's Aid Society workers in meetings are writing stuff down, and then they have to transfer within 24 hours into their database. Not everything is caught. Not everything is even experienced by them properly, and not everything winds up in the databases. And a lot of these people themselves, even though they should be, are not trained to think forensically. So I always look at it as the who, what, when, where, why. The child's right in the middle of it. And of course, we're going to hear them, but how we hear them should vary depending on the circumstances. And again, just given the time allotment, these slides are very deep, and we'll have a cleaned up version of this that would be available for everybody. The child's voice is always going to be looked at because of the Convention on the Rights of the Child and its implementation in federal and provincial legislation. But it's important to understand what the convention actually says and what the convention doesn't say. The convention does not say every child gets their own lawyer. The convention does not say we always have to do what the child wants. The convention merely says that the contracting states have to put something in effect so that the voice of the child can be solicited, but in context. So all you hear from those who want to manipulate children or who are children's rights advocates, and that's all that matters, not their best interest, just what they say, what they want, is Article 12. But they ignore all the other parts of the convention, the vast majority of the provisions of which are designed to ensure that children will have the right to both parents in their lives. And it's those other sections of the convention that just simply don't get the play that Article 12 does. Even when you're literally listening to a child, and of course, in child speak, if you're listening to me, you're going to do what I said, because then if you don't, then you didn't listen to me. So there, of course, they don't understand the subtlety of, I heard you, but I processed it, and there's some other considerations. So your voice has been heard, you participated in the process, but the adults have to make the decisions, is lost on children. You have the child that presents, then you have the authentic child inside, who would really generally just like to have both of their parents and be freed from the loyalty bind, the triangulation, the pressure, the guilt, and the grief of the loss of a parent and of being forced to carry out one parent's agenda. Now, this is a chart that relates to interviewing Children's Aid Society workers and trying to really understand where they get their information from. But it could easily apply to a therapist, a parental coordinator, a court. Ultimately, when you really follow the trail of assertions, you'll find that many of them have never been independently verified along the way, and they're just each one passes it on to the next one, and then the source of the allegation or understanding is lost, but when it's traced back, you suddenly find that the root is wrong. So it's very important to unpack the files and assertions and knowledge of each player along the way to find out where they got their information from. We rarely see the voice of the child subjected to the same level of scrutiny from a credibility and reliability perspective as we do the adults. And that, of course, is quite problematic. Often the voice of the child is just put forward into court as if it's truth, without the background knowledge that the court needs. Who was in the room at the time of the interview? Who was the child living with at the time of the interview? Who took the child to the interview? And even more importantly, who was going to pick up the child immediately after the interview and debrief with the child? Who might have been listening in from the hallway? Supposed to be a private interview by child protection with children at parent A's house. But if the child knows that parent A is lingering in the hallway outside their bedroom, the caseworker doesn't, then the caseworker is going to be misled. When you're dealing with assertions from the parent who's making the false allegations, there's a common rhetoric. It's almost like they're all reading from the same book. So those of us who service the targeted parent communities have to work real hard and do a ton of reading and research and attend conferences like this one to learn how to counter a stream of false allegations. And it just seems that quite often the parents and their representatives on the other side are there must be some book out there because they're all speaking the same language, but it's not. It's just common, intuitive ways to attempt to mislead and to undermine, and a common rhetoric. I can't force them. No one's asking you to force them. We're asking you to require them, to teach them, to reframe for them, to guide them, to incentivize them, to use your parental authority to clear up this misconception. So again, the rhetoric is important, and it's important to know the responding rhetoric, if you will. So I'll just skip through this. Somewhat esoteric topic, but increasingly rearing its head as our research gets better, is understanding the neuroscience that is involved in the world of false allegations. Why do children have a propensity to lie and try and mislead? Why are children amenable to themselves being misled so easily? And is there something about that magical age where the teen brain changes start happening, where we tend to see 10 to 11-year-old girls and 11 to 12-year-old boys who were not totally immune, but relatively immune, I'll use a hockey term, to the chirping going on at one parent's house, who suddenly just, it's almost like they surrender. And then they are no longer able to withstand that and maintain two realities. So dad's house is unsafe when viewed from the lens of mom's house, but my actual experience at dad's house is it's great and I have fun and I am safe. Younger kid can quite often tolerate that. You hit this age and they can no longer tolerate the two realities. One reality has to win out. There is a neuroscience basis to that. So in terms of research, it's something that is fascinating. I have a huge library on all of this if anybody's interested in, but I do want to get us to some of the more practical tips for the forensic that I was referring to. So I'm just going to jump ahead. I mentioned before that we do have to get the voice of the child before the court and into these other forums. Some ways are better and more reliable, do less damage than other ways. The worst way is to give the child a lawyer, because under our law, at least here in Ontario and in most other jurisdictions, counsel for the child, it's basically the same relationship as counsel for the parents. It's an advocacy role. It is not a best interest role. Also, lawyers are not trained in these forensics. And if a lawyer kind of suspected the child's voice might not be reliable, well, it's not necessarily their job to put that before the court. But there is guidance that they're supposed to do that. A judicial interview is very frowned upon. Judges are supposed to be not creating their own evidence, if you will, and can be swayed, like any human being can be swayed by a tearful child saying, I just want this, I just want that, I'm really not happy there. That's supposed to be filtered for the court through a trained therapist or assessor who can put the child's views, preferences, and experiences to the court in context. So you want a skilled clinician who themselves is doing a forensic to be the route to get the voice of the child before the court in a reliable way. Now, part of the swirl of false allegations are criticisms of one parent's parenting, and to an absurd level. The most common complaint of an alienated child is he or she yelled at me. I've never met an alienated child who isn't saying that. But when you probe, when you're trained in the forensic, you find that they will put the label, the piece of rhetoric, on any time that a parent exercises parenting. So if you say no, or you have a defined bedtime, or there's chores in the house, he or she was yelling at me. Yelling can simply mean asking the child to do something that they don't want to do, or asking the child to refrain from something that they do want to do, is then going to be reported to an assessor or a therapist or a children's lawyer as mean and yelling. It's just rhetoric. And it leaves aside, it creates a standard of know-it-all perfection on the part of the targeted parent that does not apply in an intact family. In an intact family, there's a very broad range of parental behaviors that will be considered as capable of leading a child to healthy development and a healthy approach to adulthood with all the tools they need, all the tasks they have to accomplish in childhood. We apply a much more tougher standard, sometimes even a hypocritical standard, to parents after separation compared to parents in intact families. And this is often forgotten. So I'm going to move ahead to some of the tools in this forensic that I keep talking about. Here's a great piece of judicial rhetoric. If you look at the middle paragraph, although she became adept at articulating support for the axis between the children and their father, it is clear now that her articulation was hollow, completely devoid of any meaningful substance. I use that one all the time. It's from one of my cases. And it is in response to the alienating parent. They always say, I understand why the children hate or despise or have anxiety about the other parent, why they don't want to go. But of course, I'm encouraging them to go because there's a court on encouraging them to go. But I understand why they don't want to go. Well, the law on compliance with parenting orders is very clear that encouraging is not good enough. It's not a safe harbor. But how much truth can there be if that is really your experience of the other parent? So a good forensic is to create a list of all the pejoratives that the favored parent has about the other parent. And in cross-examination, go through it with them just to make sure. We're going to address them one at a time, ma'am or sir. I just want to make sure I've got your list correctly. And you go through the whole thing. And did I capture it all? And right now they're looking at you like you're one of the worst lawyers in history because you're making their case for them. And then you hit them at the end of that saying, well, if that is your view of your co-parent, you couldn't possibly be supporting the relationship between the child and them. So the trap has been set. It's one of the forensics. I actually used that in this particular case. It worked out very well. So you have the view of the world. And again, because time is short, I won't go through this in detail, but there's a very common view of the world from the favored parent's perspective, from the targeted parent's perspective. There are common mistakes that courts make. There are common mistakes that therapists make. Sending a family off for therapy without the structure, are all oars pulling in the same direction? Is the therapy just going to become another forum for everybody to debate who's right and nothing will be achieved? You have to see these mistakes being made over and over and over again to realize that we're not doing this right. Should never send a family to therapy for the therapist to kind of figure it out or make a parenting plan. That's a confusion of the roles. You have to figure out the reality in advance, or at least that all the goals are aligned and that there's a settled parenting plan, and that the therapist is just supposed to unpack narratives, resolve them, and enable everybody to move on. Otherwise, there's no point. So we're supposed to learn from the continual, repetitive views of the world that we see. So I've tried to compile them here on these slides. So you have the favored parents narrative, you have the rejected parents narrative, you have the children's narrative, you have hidden stuff that is always there, Canada's famous child support guidelines and a 40% cliff. So where do a lot of the fights take place? Between a 9 and 5 schedule or an 8 and 6 schedule, which science tells us, Professor Kruk has done some amazing studies, that in and around the 40% mark, anywhere in there, children's experience over the course of an entire year, they're going to have 2 primary parents. It'll be very similar to what life was like before. So why the big fight about can't let that other parent go to an 8 and 6 schedule as opposed to a 9 and 5 schedule? Because it's going to affect child support. So that that requires systemic reform. There are mistakes that courts time and time again are making that if you see it, then bake it into your knowledge of the forensic that's required to get it right. And again, there's a lot here, and I'll make this available. The track record of therapy in cases of false allegations and manipulation, gatekeeping, enmeshment is poor, sometimes abysmally poor, but it's one of the few tools we have. So to blindly rush in and have a therapist make the same mistake over and over again, and another family loses that crucial window where things might have been turned around, seems rather amateurish. And we're playing around here with the most important thing in the world, which is our children. So you need to pick the right sort of therapist. It has to be a directive mandate. I have a standard set of covenants that I insist on prior to any therapeutic intervention. And the covenants are meant to empower the therapist, actually to direct the therapist, and to ensure that both parents are going to act in support of the process and not frustrate the process. So if anybody's interested in those, I'm happy to send those to you as well, in order that we avoid the, I think there's 3 slides worth of mistaken therapist narratives, no 2. And then, of course, we have the missing narratives. Some of the things I've been talking about are part of this forensic as well. This results in not approaching these swirling worlds of conflicting allegations and narratives with knowledge of this forensic leads to failed assessments and legal cases gone wrong. You do have to approach these difficult cases from an evidence-based, scientific perspective if you expect the system to get it right. Okay, so I'm actually gonna just linger on this slide for a second. Quite often we have these family systems, they've been stuck in some state for 3 years, 4 years. They've gone through multiple therapeutic interventions. I had one case that went to trial. There were 10 separate interventions: psychotherapists, psychiatrists, psychologists, social worker, family counselor, parental coordination, then back again for like round 2. Expecting things would be different, which of course is the layman's definition of insanity. Why is a family system stuck? They're meant to heal, just like human relationships are meant to heal. If they're not healing, somebody is motivated for it not to heal. People are anchored on those narratives that cause them to be stuck and not to heal. So why are they anchored on those narratives? Because those narratives give them power. If I keep asserting X, nobody can force me to move off that and spend time with the parent who I don't want to spend time with. So I'm going to hold on to that narrative, that fictional event or event that has been blown out of all proportion. And I'm never going to forgive it. I'm never going to forget. I'm never going to let it go. And I'm never going to be open to, maybe I got that wrong, or maybe I'm not being charitable about this, or maybe I'm making too much of it, or maybe enough time has gone by, we should just let it go. Because the minute I do that, I'm going to be expected to move forward and spend time with the other parent. So lack of progress is itself a key diagnostic tool. We want to find out why. Now, a lot of the people intervening in these families are themselves subject to various cognitive biases. And there's a website where all the possible cognitive biases are collected. And the name escapes me right now, but I actually have the chart. And they link them in groups, and they show the interlinkages. There's something like 223 different types of cognitive biases, errors in reasoning and critical thinking skills that a human being can be subject to. There's some that are particularly common, particularly in these cases, and that's anchoring. I described an example of anchoring. But there's also confirmatory bias. You form a view of a situation early on, and everything else that you see and learn along the way gets filtered by that view, instead of maintaining 4 or 5 or 6 clinical hypotheses that are open, and they kind of rise and fall in terms of likely correctness over time as new information keeps coming in. But your view is kind of open till you get to the end of all the data collection and testing. You maintain an open mind. You actually have to be trained to be able to do that. Good colleague and friend, Dr. Steve Miller, who recently passed, has written an excellent chapter in one of the clinical books that we all use on cognitive biases and heuristics and things of that sort. And if anybody's interested, I'll be able to give you the reference. So I'm going to move forward to something that I really view as really the heart of the forensic. How do you prove a negative? If you're subject to a false allegation, at the end of the day, we're expecting you to prove a negative instead of where the emphasis should be. Gosh, that allegation is really significant. It has not been my experience that this person has acted that way. So the emphasis on you, the person propagating that allegation, that extreme allegation, to prove it, because it seems to be out of character for this person. That has to be the starting point, but it usually isn't. And as I point out in the second line, the most abused word in the English language is the word abuse, because it's just abuse in the eye of the holder, so to speak. So we need all that background knowledge, much of which in the interest of time I skipped past, to come down to, there's about 10 to 15 tools. So let's go to the tools. Tool 1, assemble objectively determinable facts and observations from third parties about behavior before the incident, the event, the decline in the relationship, during, and after. That forms an important vantage point. You're looking for the illogic and the discontinuities. The classic discontinuity, and I was just in Owen Sound arguing a case a couple of days ago. So you have an allegation of something that happened mid-December. Child goes back to that parent for a Christmas week ending about December 27th. There are collaterals there. Everything's great. Love is flowing. No one's talking about this alleged incident from a week or two before. It ends well. See you again in a week when I'm back with you. Looking forward to it. Child never comes back. Hasn't come back since. Can't get the child to transition. I'm sorry, but there's a fundamental illogic here. I don't have to go too much further to know who's lying here, because that's not how the human mind works. Fundamental disconnect in the timeline. Tool 2, the illogical or atypical manner in which the allegations arose. So 3 weeks after the fact, you find out about something that allegedly occurred 3 weeks before, significant enough that the child doesn't want to come anymore. That's not how those happen. You hear about those in the moment. Calls going back and forth, somebody phoning CAS, hurt feelings, grandparents being told about it. Something that significant is not stealth until 3 weeks later. Fundamental illogic. Tool 3, the recovered memory. So once one bad thing comes out, all of a sudden, and he or she neglected me for years, et cetera, a whole bunch of other stuff comes out of the woodwork. Can you recover a memory of abuse extending over a long period of time? Well, it is hard. There are fewer and fewer people around who remember the recovered memory industry that existed in the 70s and 80s, and the pushback from Elizabeth Loftus, one of the world's experts in how memory works, and many others. There's foundations that were formed to study this. It is unfortunate, but there was a whole generation of therapists who were trained that problematic behavior usually has its roots in some sort of historical abuse that the person just hasn't gotten in touch with, and we just had to, like lancing a boil, kind of bring it out, and they would literally implant the memory that wasn't there before. We're way past that. Memory science today, you have to understand memory science. All memories become more diffuse over time, both good memories and bad memories. Memory is not like a digital music file that you can recall and play 1,000 times, and bit by bit by bit, it will be perfection and unchanged. Memory is the exact opposite. Every single time you recall a memory from long-term to short-term memory, it is changed. When it is re-encoded into long-term memory, it is different. If you are living in a home that is invalidating of the child's experience about the other home, there's no way your memories of that other parent or home are going to be untainted. These are just fundamentals of memory science. If you're going to play in the field of false allegations and real high conflict situations, you must read up on memory science. Tool 4. There are formal heuristics that can be used in these circumstances. Tool 5. Children will often, when they're interviewed by a school counselor or a therapist, say, well, I'm going to tell you, but you can't tell my mom. You got to promise me you won't tell my mom what I'm telling you. 99% of the time, that's because they know it's not true. The other 1%, I don't want to hurt their feelings. But if you have an experience, you want it solved, you want the relationship to heal and get better, then of course you want it. You not only want it shared, you want to invite that parent into the room so that we can all talk about it and solve it. One of the signs that you're dealing with a therapist who doesn't know what they're doing is if everything is siloed. And I've had this many times from assessors and therapists. They'll meet one parent alone, the child alone, the other parent alone. The child has complaints about parent A. They won't get the child and parent A in the room at the same time to watch the dialogue, watch the negotiation, watch the resolution or the concrete anchored thinking. Huge mistake. Tool 6. The child outwardly has no fears or anxieties, but get them being interviewed and everything spills out. Just to show, etc. Now, I know I must be running short of time. There's a series of tools. The tools, there's 15 tools. And it's important to master all these tools as part of this forensic. Now, you'll notice I haven't really been mentioning any law, this statutory provision, this case. This stuff pervades every forum, the therapeutic forum, the legal forum, the Criminal Justice Forum, the Youth Protection Forum, these sorts of heuristics. So at the end of this presentation, there's just a couple of slides. Oh, I do want to linger on one thing, using demonstrative evidence. So one of the tools is try and create a picture of what was going on. So I've used these pictures in many different ways. I had one trial with false allegations of sexual abuse where when you drew a map of the layout of the house where it was supposed to have taken place, the picture itself in relation to the assertions showed that it was impossible. It was too open plan a house for this actually to have taken place. Other times you have to do more of a graphic that shows how false allegations, firstly, how many of them were they, and how have they changed over time. So something was prominent in the affidavits in 2019 and then disappears, even though there's been no formal resolution. A picture. Okay, I can see I'm out of time.
Yeah.
And I want to let everybody get on, but you can see how rich this area is.
Yes, absolutely.
Thank you, Brian.
Okay, my pleasure.
Thank you.